Hello, and welcome to the Native American Natural Resources class in the Master of Legal Studies program at the University of Oklahoma College of Law. My name is Taiawagi Helton. I teach in the areas of Indian law, environmental law, and property, and I'll be guiding you through this course. By Native American, I refer to the indigenous people in the lower 48 states. For the most part, Alaska Natives and Native Hawaiians have different rules that govern their relationships with the United States. We'll be focusing primarily on Indian law in the lower 48 states. I use the term Indian interchangeably with Native American, in part because that's the term used in federal law. Title 25 of the United States Code is entitled Indians, and also in part because that term continues to be used in a number of Native American communities. When we discuss tribes, we refer not only to tribes as kinship and cultural groups, but also as sovereign entities. We focus on natural resources because conflicts over land, minerals, timber, fisheries, and other natural resources have been integral to the relationship between the United States and Indian tribes. But we won't talk only about natural resources. Indian law is inherently interdisciplinary, and we will be discussing history, policy, and law. Those three are intertwined because Congress is the primary lawmaking body and the primary policy-making body in this field. Indian law is unique in that regard. We will also talk about constitutional law, looking at how group rights, tribal sovereignty and tribal rights, have a place in a liberal democracy. That is, in a democracy that focuses on individual liberty rather than on communal or group rights. Inevitably, because of the nature of this material, we will discuss race, and I encourage respectful dialogue as you discuss the materials. There are three sources of law relating to Native Americans. Tribal law, because tribes are sovereigns and they pass laws to govern themselves and govern conduct within their boundaries. International law also governs the rights of indigenous peoples. And third, federal Indian law. We will focus primarily on federal Indian law because the federal government has been historically the dominant actor and the dominant lawmaker in this area. We will see 5 themes in this course. First, Indian law is all about jurisdiction, claims of authority by sovereigns over people, property, and resources and land that are the subject of this course. The second theme is civics. You probably learned in your high school civics class that we have a system of bilateral federalism with a national government of limited enumerated powers. Neither of those are true. Instead, we have 3 sovereigns. Tribes have been recognized as such by the predecessor nations of the United States, which has 371 treaties with tribal nations. Moreover, the federal government's power is not limited to those enumerated in the Constitution. The Supreme Court has held that federal power over Indian affairs is not found in the text of the Constitution. Rather, it arises of the unique relationship between the United States and Indian tribes, a historical relationship. The third theme is the critical distinction between property and sovereignty. It's not always a distinction recognized by the courts, but it is an important one. Sovereign regulatory control is independent of ownership, and tribes may be both sovereigns and property owners at the same time. The next theme in the course is the tension between the current federal policy era of promoting tribal self-determination and the federal government's trust responsibilities owed to Indians. The federal government, on the one hand, wants to promote tribal autonomy and economic self-sufficiency. On the other hand, it has obligations of oversight, and those two things are sometimes in tension. Finally, complexity is a theme. The lack of universal principles makes Indian law fascinatingly complex, or frustratingly complex for those who desire certainty. Federal Indian law is a mixture of often contradictory treaties, constitutional provisions, statutes, and cases. Congress has changed its predominant policy a number of times throughout the history of U.S.-Indian relations, but even when it has repudiated a prior policy, it often has simply passed laws representing a new policy without repealing the earlier ones. Consequently, courts and students must wrestle with a statute reflecting past policy in a later era. Pay attention to the dominant policy era in which a statute was passed, as well as the predominant policy era at the time of judicial review. As you can see from the syllabus, we will look at 8 major subject areas. First, we'll talk about land, religion, and culture, because cultural views as to how humans ought to relate with the land shape both law and policy. We will also consider legal protections for tribal religions and cultural resources. Second, we will briefly cover the basics of federal Indian law, beginning with a survey of the history of federal Indian law and policy, founded on 3 cases known as the Marshall Trilogy. Decided in the early 1800s, these cases helped define the role of the courts and Congress, and also the relationship between tribal sovereigns and the United States. The basics include tribal sovereignty. Tribes are pre-constitutional sovereigns whose sovereignty is inherent in their status as self-governing peoples. The federal role in Indian country follows with the definition of Indian country, a legal term of art that designates a geographic area as having special jurisdictional rules. After we've covered the basics of federal Indian law, our third major topic is land. Tribes may hold aboriginal title, that is, ownership of land held exclusively since time immemorial. Recognized title is ownership that has been acknowledged by Congress in a treaty or a statute. Between 1850 and World War I, there were also a number of reservations created by executive order. We will then look at a special category, submerged lands, found beneath the ordinary high water mark of navigable waters. Finally, we will look at allotments. Fourth, we will examine land use and environmental protection. As to authority to control land use, there is competition between the tribal, federal, and state sovereigns. Modern environmental protection in Indian country involves tribes as both regulators and as regulated parties, and the EPA has been increasingly treating tribes as states so that they can be incorporated rather straightforwardly into the system of environmental federalism or cooperative federalism. Fifth, we will look at natural resources development, minerals, oil and gas, and timber. We will see that the federal government has an important role in the development of natural resources and also has trust obligations that may give rise to a breach of trust claim for mismanagement. In the modern era, tribes have had more control over natural resources within their regions than has been historically the case. And we'll see that their development has tended to be more sustainable and more environmentally appropriate than has historically been true. Of course, natural resource development results in financial gains that are attractive for taxation. In our 6th topic, we will see that again, 3 sovereigns may claim an interest in taxing the development of natural resources in Indian country. 7th, we cover usufructs or usufructuary rights, hunting, fishing, whaling, and gathering. Finally, we will focus briefly on international law and the rights of indigenous peoples to land and natural resources. Just as a note, we will not cover water rights in this course. That topic is important enough that the MLS program includes a class dedicated to that subject alone. I look forward to our discussions, and I hope that by the time we are done, you will have a fairly broad understanding of natural resources, environmental protection, and jurisdiction in Indian country.